Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. We will start our day with Judge Simpson.
Not going to be the basis for an adjournment.
Yes, Judge. I am on the line and I'm aware of that. Thank you.
Ms. Barnwell, you're aware of that?
Yes, Judge.
What dates were you talking about?
July 15th?
Yes, July 15th works for me.
We don't operate that way. You guys know that, right? I'll do it this time, but we don't operate that way. Preliminary examination in person will be set July 15th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Judge.
Court does call the case People versus Mariah Thomas.
Irma Dadush on behalf of Ms. Thomas. Ms. Thomas, can you please state your name for the record?
Mariah Thomas.
Thank you.
Your Honor, we're going to be asking for a brief adjournment to continue plea negotiations with prosecution.
Probable cause conference will be adjourned to June 26th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
June what?
Court does call the cases of the People versus Spencer Norton. 4 cases.
And listed on behalf of the people, Your Honor. No. Private, it says no comment.
Was he here?
It's no comment.
Jeff Perlman? We check in with you. I'll pass the matters. Court calls cases in the case of the People versus Rafael de la Cruz.
Morning, Your Honor. James McNally, Special Assistant Attorney General on behalf of the people.
Thank you.
Irma Dadush on behalf of Mr. De La Cruz.
De la Cruz, can you state your name, please? See here.
I do not know what Mr. Dillon is here.
He did tell me he is on the Zoom.
Rafael de la Cruz? I don't have him.
Can Your Honor please pass on this? I'm going to give him a quick.
I have
Oh,
118
that's
cases.
not him.
Rafael de la Cruz?
I see his name on the screen up there.
That's Rafael Chavez.
Oh, Chavez, I'm sorry.
Morning,
Chavez. Good morning. What's your name?
Rafael de la Cruz.
There you go.
All right. You're not driving, are you?
No, I'm parking by the street.
Pardon?
I'm by the street.
Okay. All right. What are we doing?
Your Honor, there is an offer, the standard AG offer on this case for a delayed sentence. I was talking to AG Williams about it, and I let her know that Mr. De La Cruz is going to be taking that offer. I believe we have to waive the preliminary examination and do that in circuit court.
So he's waiving.
Yes, Your Honor.
Mr. De la Cruz, you're waiving your right to a preliminary examination?
Yes,
You understand that that's a proceeding where the people would have to show by probable cause that the
Yes.
offense alleged was committed and that you committed it?
Yes, I understand.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes,
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Deuce.
I always forget what comes
You're
after.
not-
We stand mute and wait for the reading of the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
1:30 with judgment.
August 4th, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court does call the case of the people versus Myron Barnes.
And Mr. President, on behalf of the people, Your Honor.
Geraldine Foster Tucker on behalf of Myron Barnes.
Myron Barnes. Thank you.
And Your Honor, we're just requesting an adjournment to review discovery and work towards a resolution.
You were just appointed on this matter. Probable cause conference will be adjourned June 26, 2025, 9 a.m.
that's porque me tiene
Bond
todavía.
continued.
Thank you, Your Honor.
Thank you.
Good morning once again, everybody. Welcome to the Courtroom Files Live. An update for those who were with us on the pre-show. We had wondered if Judge Boyd was going to be in today because of the protests last night, the fact that they had to close the courthouse early yesterday, and the fact that her docket was blank online. She has opened up her court, so apparently there will be some business today, so we'll keep an eye on that. In the meantime, let's get back to Judge Simpson.
People have their witnesses available June 24th.
We'll do our best, Your Honor.
Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Jason Burkett.
Good morning, Your Honor. Christina Costantino appearing on behalf of Jason Burkett.
And Your Honor, may I approach?
Mr. Burkett, could you please state your name for the record?
Jason Matthew Burkett.
All right, I have before me a plea form that indicates that we're pleading to 2 counts. Well, is he pleading to the felony?
Your Honor, today he's not the felony. Today he's pleading to the misdemeanor, but we can on his other case, which is not under your court today, that on his other case, he's going to plead on it.
The judge, he has a misdemeanor case that is scheduled for next Wednesday in the 15th District Court. This is a global resolution in which Mr. Burkett would be pleading in that file on Wednesday in the 15th. And he would.
Okay, so the only thing that he's pleading to today is the license plate title registration charge.
Yes, Judge, that's correct.
That's correct. Thank you. The plea form indicates that he's going to do that, and he's also going to plead in a 15th District Court case to count 1, the breaking and entering a vehicle to steal property, 200 to 1,000, the 1-year offense. He'll plead to that case at another time. He's going to plead to this case, and then count 1 would be dismissed.
Sure.
That's the court's full understanding of the agreement. Is that correct? May I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Go ahead and lower your hands, state your name, spell it out.
Jason Matthew Burkett.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of unlawful use of a license plate, title, or registration. That is a misdemeanor punishable by up to 90 days incarceration and or a $100 fine plus court costs. You understand that, sir?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge
Yes.
Perry in the 15th District Court.
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. Did you sign an advice of rights form, sir?
No. Not that I believe, unless it was a while ago.
You understand that because you're not having a trial, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, I do, Your Honor.
You understand you're giving up your right to appeal of right.
I'm sorry?
You're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
All right. Counsel, pursuant to the new court rule, is counsel aware of any promises, threats, or inducements that have caused this plea that have not been disclosed to the court?
No, Your Honor.
All right. Sir, on the date of September 22nd, 2024, at the location 601 South Main Street, City of Ann Arbor, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Actually, I was inside the gas station whenever I came out. The police were there.
But you had been driving the motor
Yes,
vehicle?
yes, Your Honor.
And was there something wrong with either the license plate, title, or registration on that vehicle?
Yes. It
What
wasn't,
was
it wasn't correct plate.
Pardon?
It wasn't the correct plate.
All right, so the correct plate or the plate that belonged on that vehicle was not on that vehicle?
Correct.
Is that correct?
Yes, Your Honor.
All right. Sir, I do have to advise you, and I don't know that there's been that, there's not a sentencing recommendation in this case, but if there were one and the judge does not follow that, Judge Perry, you would not be entitled to withdraw your plea as a result thereof. Do you understand that, sir?
Yes, Your Honor.
I also have to advise you that if I accept your plea and you commit misconduct after this plea is accepted prior to the time of sentencing, you're not entitled to withdraw your plea unless allowed by the court for a good cause. You
Yes.
understand that, sir?
Yes, Your Honor.
All right, counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two, excuse me. Count one is dismissed. Pre-sentence investigation is ordered at 15th District Court probation. Sentencing in this matter will be
July 3rd, 2025, 10 a.m. Judge Perry.
July 3rd, 2025, 10 a.m. Judge Perry.
Yeah.
Bond.
Thank you, Judge. And could I address
you.
bond briefly?
Yes.
Judge, my client has been in custody now for about 21 days. He did, as Your Honor knows, just enter a plea for a misdemeanor that carries a maximum of 90 days in county jail. Should he be released, he does have employment lined up. He was working at Petaway prior to his incarceration, and if he is released, he would be able to return to his employment there. He would be residing at the Delana Center, which obviously is very close in proximity to the 15th District Court. He has been staying at the Delana Center since last March. He is in the process of getting some more permanent housing set up, but obviously has had some difficulties doing so from the jail. He will be set up with community mental health upon release. And he has a peer recovery coach that he would be working with as well upon release. Given that, we would ask the court to consider a personal bond.
When is he got a PR on his other case?
He doesn't, Judge, but it's my understanding that Judge Perry indicated that if his bond was amended in our case, that she would amend his bond on this coming Wednesday to a personal bond. And his court date's this Wednesday, June 18th, before Judge Perry.
Or not soon as they said they would check in with the court system today, later on today. My other lawyer, Delphine.
what I'm going to do in this case, I guess technically I would deny it with this modification, or actually grant it but do it this way. I'll continue his bond at this time. However, I will grant him a PR effective July 18, 2025.
Thank you, Your Honor.
Thank you, Judge. And I just want to make sure the court said June 18th, or did the court say July 18th?
If I said July, I meant June 18th.
Okay, thank you very much.
All right. Here.
Let's travel down the interstate. We'll go from Michigan down to Florida, Jackson County to be specific. Wade Mercer is doing first appearances.
Provided to the attorneys, so no one knew about your court date last week until yesterday when you mentioned it. So, Mr. Ivey, you're here on the charge of violation of state probation. We're just going to try to keep the case moving. So I'm going to ask Mr. Gill from the state attorney's office to tell me what their position is as far as setting this and trying to get this thing resolved. Listen to Mr. Gill, and then we'll listen to Mr. McDaniel, and we'll see if you have any questions. Mr. Gill?
Thank you, Judge. We're fine with setting this for a final hearing. I just need enough time to get my subpoenas out, Judge. So whenever the court is available, we'll be ready to go to a final hearing.
Thank you. Now, Mr. McDaniel, I know Mr. Green's not here. He had a court date somewhere else. But what I'd like to do is set it on a day that they're already going to be here.
Be July 10th, but they have all those other VOP hearings with the other judge.
So Lindsay, you're down there in felony court. If I set it on July 10th, then you've already got that. Tell me how the felony VOP docket is structured now. Is it 1 day a month for hearings and pretrials? Everything's on 1 day? Is it an all-day docket? Okay, so is the morning different than the afternoon? Like the morning, is the hearing afternoons in the hearings in the afternoon, or what? Okay. So if you have a hearing, when is it? Morning or afternoon?
Generally the afternoon, sometimes the morning if there's room, but generally they're slated. All hearings are in the afternoon. The docket is docketed for the morning.
What time in the afternoon does she start down there? What if we set this at 1 that afternoon?
I mentioned that to Mr. Green, and he said he thought he had some other hearings and stuff, but he said that he'll work with whatever. I suspect if we said that 1, it may be a little bit later as according to what's going on.
And it may get resolved. I have no idea. Right. But Mr. Ivey, I need to keep this case moving. Frankly, I want to get over with, and you've been sitting in jail a while with no bond. So what I'm going to do is I'm going to schedule you for a violation of probation hearing at 1 o'clock. And what's that date?
July 10th.
July 10th. I should check my own calendar since it's. Let me check that. July 10th at 1 o'clock.
What I'm trying to do, Your Honor, is I'm trying to resolve
give me just a second. I'm gonna give you a chance to ask questions, but I want to make sure you understand. July 10th at 1 o'clock. Yeah, I have private attorney docket at 1:30. But if there is a VOP hearing, and I don't know there will be, if there is, the allegations are new trespassing and a positive analysis, which I think he admitted to. So it's not going to be a complicated VOP hearing if we have to have one. Either the state can prove it or they can't.
Correct. And I provided the blue man in discovery to Mr. Green.
So, Mr. Ivey, just because I'm setting it for hearing doesn't mean there's going to be a hearing. Okay. I know that you haven't even had a chance to talk to Mr. Green, and that's going to happen hopefully in the next few days. And then we're going to see if we can get it resolved. If we can get it resolved, then we'll resolve it on the 10th or possibly even before then. If not, we have it set for a hearing on the 10th, which is almost a month away. So I'm going to ask Mr. McDaniel to ask Mr. Green to come see you in the next few days, and we'll see what happens. Right now, the state has the misdemeanor trespassing, which is scheduled for a pretrial July 9th. So we'll see what happens, but it may resolve it all on July 9th. Actually, I don't know if we can do that. We'll have to have probation, or at least the felony clerk here. I guess it's a VOP, so I have to have probation here too. So that's where we stand. I just want to try to keep this thing moving. If Mr. Green, that doesn't work, he has addition, he's asked for continuous for some reason, then we'll cross that bridge if it comes up. But since you didn't get seen last week like you should have, I'm trying to get your case moving. Mr. Ivey, don't talk about your case. Don't talk about the specifics of your case. You need to do that with an attorney in private. But if you have questions, and if it's a question I can answer, I will try. You have any questions?
Yes, sir. There's no way I can get this thing resolved to tack on a year probation, because the simple fact is I knew I can beat the trespass and the dirty urine. I'm just saying, because I asked for a DNA from the lab from the dirty urine. And
Mr. Ivey, this is not Mr. Ivey. This is Mr. McDaniel, this is not the point where we're going to negotiate over the first appearance stuff. So I mean, we're not going to negotiate right here.
Let me ask a question, Mr. Gill, because when I did VOPs, look, he's confident that trespassing. Mr. Ivey's confident there's defense to the trespassing. I have no idea. But when I did VOPs, even if there's a defense to the trespassing, he can still, if it's a first violation for a positive urinalysis, the most he can receive is 90 days in jail or house arrest with inpatient drug treatment.
Correct, Judge. So a positive UA by what Mr. Ivey's been violated for would be a low-risk technical violation. That is correct. So if the state did prove the trespass, it would not be a low-risk technical violation. And on a low-risk technical violation, generally, the state's offer is 90 days reinstate, usually add a year to supervision, sometimes inpatient drug treatment, things like that.
So what I can tell you is me knowing your history, knowing your case, if the trespass goes away, I'm probably going to sentence you to inpatient drug treatment and community control. So that's probably what's coming if the trespass goes away. But right now, the trespass has not gone away. And the state's offer they made you yesterday, which you probably hadn't even seen yet, was 18 months.
18 months DOC.
So the state's offer yesterday, which they sent to you and your attorney, or sent to your attorney, which your attorney will bring to you, is 18 months prison. So what I'm saying is, even if the trespass goes away, the chance of me putting you back on probation or extending your probation without requiring you to go to drug treatment is not very good. I'm probably going to make you go to drug treatment and probably going to put some community control on there if the state can prove only that violation. Now, if they can't, then they can't. But I'm just trying to get your case moving. Do you have any other questions, Mr. Ivey?
Yes, sir. Can I get the FDLE lab from the report from the urine analysis test?
Can you get a what?
The FDLE lab report from the fish.
It's probably not an FDLE lab report. If there is a report, it'd be a different company. Mr. Gill, on the lab result, was it an admission or was it a lab result? And who was the?
Judge, my understanding, I've not seen any lab report yet. From my understanding, it was done by a bailiff at the jail. So I don't believe there's going to be anything but testimony as to the positive UA.
Okay.
There is maybe other evidence that the state has, but as far as the UA goes itself, that should be, from my understanding, all that we have is testimony to that.
So, Mr. Ivey, there's multiple ways the state can try to prove a positive urinalysis. A lab report is one way. Another way is other types of tests. Another way is possible admissions or statements by the defendant. So that they may not have an FDLE. Matter of fact, they never have an FDLE lab report in a positive UA. FDLE analyzes substances, physical substances. FDLE doesn't analyze urine, as far as I know, at least not in a VOP hearing. That would be either a company or an admission that you allegedly made. So we're going to see you on that day. If I don't see you before, Mr. Green will come see you. And if we have it worked out, something everybody can live with, I'll see you before then. Okay?
Yes, sir. Yes, sir.
All right. Have a good day, Mr. Ivey.
Yes, sir.
Mr. Gill, is that all you have?
It is, Judge. May I be excused?
Yes, sir. Thank
Thank
you.
you.
All right, ladies and gentlemen, we have a regular first appearance docket. Thank you, Mr. Jernigan. We have our regular first appearance docket, and I know that I see some people in the courtroom. You may be here, traffic court today also? No? Is traffic court today, ladies? Lindsay, Dawn, is traffic court today? Okay. Ma'am, on the third row, are you here for a first appearance case? What case are you here for? And do you want him to know that you're here? So what's your relationship so I can tell him? Okay. And sir, in the back, are you here for a first appearance case? Traffic court? Okay. So we do have traffic court. At least we got SBI hearing, I think. All right. So the next case will be Kayla Boston. Mr. Boston, good morning. Mr. Boston, your wife is in the courtroom. You're here because you have a warrant out of Leon County. I did take a look at that warrant. And Mr. Boston, that warrant has no bond on it. You're going to be held with no bond until you can get over to Leon County. Mr. Boston, that could happen. Today's Thursday. It could happen this week. It also would not be unusual if it didn't happen until next week. When you get to Leon County, you'll go to another first appearance there, and that first appearance judge will address your bond status. But right now, you have no bond. Mr. Boston, do you have any questions?
Yes, sir. So
Okay.
on the arrest, they got me for pleading and eluding, but I never did none
Mr.
of that.
Boston, I've already talked to you about this. There's nothing that this court can do about that arrest warrant.
Look, sir. I don't care what you have to say. You're not helping me out.
Yeah, well, you've got no bond, and he's right. Mr. McDaniel's right. I don't have authority. I don't have authority to modify another judge's bond from a different circuit. So you've got no bond. You've got to deal with that court that's accusing you of this. So you'll be over there the next few days.
Is there any way I can contact them?
You have the right to use the phone after first appearance. Absolutely. You get the right to use the phone anytime you come to first appearance and you're told you have a bond or not. Your wife's in the courtroom. She also could contact them also, but he's got no bond for the time being. All right. Have a good day, Mr. Boston. We have Quantavious Pigler. Is there another VOSP? There is. Actually, we already saw Mr. Ivy. So just Mr. Pigler. Mr. Pigler, good morning, pleasure. You're accused of violating the terms of your state probation, Mr. Pigler. Got a copy of the warrant in front of me, and there's a no bond warrant, Mr. Pigler. What that means is you've got no bond. I want to get you arraigned today because I want to get you appointed a lawyer if you're asking for one. Would you like to have an attorney appointed to represent you in the VOP?
I have a question before I answer that.
Okay.
What do they say the probable cause is of me violating my right terms of my probation?
All right. The allegation against you is that you allegedly had contact with the alleged victim that you were ordered to have no contact with.
Mr. Pigler, do not comment. I know I talked to you out there earlier. Do not comment because anything you say is going to be used against you at a hearing.
Yeah. So the allegation is that the alleged victim drove you all the way from Polk County to the probation office, and they're accusing you. They're saying that was a violation of your probation. Again, don't comment on it. I'm just trying to answer your question. So would you like to have an attorney appointed to represent you?
Okay, well, I have one more question. Okay, why can there not be any comment? If isn't this being like transcribed?
It's being recorded. It's being recorded. Your attorney doesn't want you to say anything to hurt yourself. He'd rather you talk to an attorney in private. And then once you talk to an attorney in private, then that's the time to express your defenses. But
is this court appearance right now being transcribed? Like, is it being written down?
No, it's not being transcribed. No, it's being recorded. There's a video recording of what's going on today.
Okay, well, I understand. Well, I want to say that my rights are being broken by this warrant being placed on me by an allegation, because any allegation can be placed against me and I can be arrested for whatever reason. That's no probable cause.
You have no idea what you're talking about. Someone has accused you, a probation officer has accused you of violating the terms of probation in the manner I just described, and that is probable cause. If someone told your probation officer that happened, that is probable cause. Do you want an attorney appointed to represent you or not?
And I have to wait until I go to court to prove my innocence on the 10th, on my next court date?
According to according to the affidavit filed by your probation officer, you and the victim, the person you could have no contact with, both said that she drove you. So the answer to your question is you don't have to prove anything. The state has to prove you violated your probation, but because you're on probation, you're not entitled to a bond until your court date.
Well,
the best thing I can do is get you a lawyer. Stop interrupting me, or the hearing's going to be over with. I'm going to just stop it. You can just go back to your cell. So what I'm going to tell you is the best thing I can. Have a good day. So he's not been arraigned, Sergeant. You should make a note of that. When he comes to court for Judge Garcia, make sure they know he's not been appointed to the public defender's office. Next case is Zachary Gibson.
We don't decide, it's fine. We don't care. Yeah, it's been reported already, so that's all I need to say.
Sergeant, the best thing you do is get him out of the first appearance room before I have a contempt hearing. So he needs to leave. Mr. Gibson, good morning. Mr. Gibson, you're here because you're accused of failure to appear on the charge of fleeing and eluding. The circuit judge has signed a no bond warrant in your case, Mr. Gibson. So what that means is you're going to be held until you can get over to circuit court and try to get this case resolved. This was an arraignment date he missed, it appears, Mr. McDaniel. So I'm assuming he's not been appointed to the public defender's office yet. So as soon as you'll get put on the next arraignment docket, Mr. Gibson, when you come to that date, if you ask for an attorney, and if you qualify for one, you'll get a permanent attorney. But right now you have no bond. Mr. Gibson, do you have any questions?
When would be my next arraignment date?
We happen to have a felony clerk here who can tell us Judge Garcia's next felony court date. When would that be? July 8th is the next arraignment court date.
All right. And thank you very much. No, sir.
Yes, sir. Have a good day.
You too.
Thank you. Warren Douglas. Mr. Douglas, good morning. Mr. Douglas, you're here because you have an out-of-county warrant out of Washington County. I've looked it up this morning, and it looks like a child support matter you have over there with a purge on it of $2,000. So what that means, Mr. Douglas, is if you post the $2,000, you'll be released and you'll go to court over there later. If you're not able to post the $2,000, you'll be held until Washington County picks you up. And then when you get there, you'll go before a judge or a hearing officer within 48 hours, or actually it's 2 working days of that, of getting there. But if you post it, if you're able to post it, you will just be released here. If not, you'll go over there. Any questions?
Can I find out when this writ was posted?
When it was issued, you mean?
Yes.
I can look that up if Mr. McDaniel doesn't know. He may know.
I don't have it right here. I
Okay.
don't have it in front of me, Mr. Douglas.
Let me look it up, Mr. Warren. And
I want to say it's within the last 2 years, when I glanced at it this morning, but I want to say it was in the last 2 years. But it's a $2,000 warrant purge, and if you make the purge, you're released. Obviously, when you get to the hearing, we'll let you know when that warrant was issued.
I'm looking it up for you, Mr. Douglas.
Thank you.
Try to answer your question. 2011-26 is the case number. The actual writ that you're in custody on. Let's see. Order of contempt and writ of attachment signed by Judge Garcia. Judge Garcia, I didn't know she did Washington County. Wait, Jackson County. Is this a Jackson County? Okay, you must have one in Washington County too. You got one in Jackson County too. I don't know if this one's been served. The Jackson County one was issued in 2022.
Mr. Gross, if you would look up the Jackson County one, and we may have there may be a writ also for Jackson County, it sounds like.
Okay.
Wow. Yeah, Sergeant Gross, it looks to me like the one in Jackson County is still active, and that one is case number 11-26DR. So, Mr. Douglas, let me go back to try to find the Washington County one. Oh, 4-255.
It's in that same time frame, I remember.
I think the Jackson one's still valid too. Yeah, the Washington County one was about the same date. It's probably a different judge though, because I don't think Judge Garcia did Washington County at any point. Judge Patterson issued the Washington County one on March 28th of 22. So that's how old it is. Any other questions?
So I have to make purge in Jackson County and Washington County?
I don't know. The jail's going to check on Jackson County. I have no idea if that one's still valid or not. When you were brought in yesterday, they're supposed to go through a process of checking any outstanding warrants. And they didn't catch this one, obviously. So it may have got served for some reason. Just my computer doesn't show it being served. But so Jackson County, I'm just telling you, there may be something there. Washington County is the one we know you have, and Washington County is the one you're being held for. If there's one out of Jackson County, what they're going to do is they're going to put you on the first appearance list tomorrow, so I can first appear you on that. But right now, you've got just Washington County is the only one that I see that's active that you've been served with. Any other questions?
No.
Yes, sir. Have a good day.
And Judge, if there is one in Jackson County, if the jail just lets the hearing officer know, we'll be seeing him tomorrow. So I don't know if he needs to come to first appearance forward, if there is one.
So did the sergeant leave the room?
Yeah, I'm right here.
So Sergeant, if there is one for Jackson County, he doesn't have to come to first appearance because it's a child support matter, but you do need to let the hearing officer know and obviously let him know the one for Jackson is still valid. And obviously that's going to stop the transport to Washington if there is one. Looks to me like there is. Thank you. We have Elijah Rodriguez.
Well, that gentleman has found himself in a messy situation, it looks like. Hopefully they get it sorted. Let's go back up to Michigan, and we'll see Judge Simpson for a little bit again.
Chelsea Court.
Okay.
With reference to the felony, are you have an objection to adjourning it 2 weeks so we keep everything together?
Could we just set everything for preliminary? Honestly,
I would
I don't
just
do
ask,
that until all discovery is complete, sir.
Everyone would need to have the discovery and know what the charges are.
so I believe
before
in
we
my,
consider.
I believe in the fleeing forth, the case that I'm representing in mine, we do have the discovery. So if possible, Judge, we would be requesting an exam on the fleeing forth.
That's right.
In that case, I do believe there's outstanding 911 calls that had the officers coming out to the scene, and those have not been received yet by the people. They were requested but not received yet.
So there is outstanding discovery on those, Mr. Perlman. The
Okay.
911 calls.
Okay. Would it be possible to send those before the exam?
Okay, so here's the way I do it. I make sure that discovery is complete because once you get to exam, courts are going to, judges here are going to be very reluctant to adjourn because you don't have discovery.
I understand. So I have no objection to a 2-week adjournment.
Probable cause conference in these matters then will be adjourned to June 26, 2025, 9 a.m. Bond on all of these matters working. Thank you.
Thank you, Judge.
Court does call the case, People versus Christie Couch.
My client's, oh, she's here. There are 4 defendants in this matter. I think you probably want to call all 4 cases at once. Because we're going to be setting an exam date and we're going to need to have calendars.
All right.
Yeah, and I'm the self-appointed.
Well, yeah, but I get sick of people telling me how to do this. I've been doing it for a while. Who are the other attorneys?
Sam Bernstein, Hannah Apple, and Mr. Norman, is it?
Yeah. Have you guys tried to figure out a date?
We didn't know what day of the week the court would want to do it, whether Tuesday or a special day.
All right, all counsels here, counsel approach. You have all that for us. Pardon?
Okay, he's going to mute for a little bit. Let's go to Texas. Judge Boyd is up and running.
Could I have parties announced, please?
Preparing for the state of Texas.
Denny Callahan, defense.
And are you Vanessa Maravete?
Yes, ma'am.
All right. You entered a plea to injury to the elderly. According to your plea bargain agreement, the state is silent on your application. And there's an affirmative finding of family violence, and this is run concurrent with a county court cause number. All right, are there any witnesses, defense?
No, Your Honor.
All right, the court will hear your argument.
Your Honor, asked the court to take notice of the jail classification. Its weakness, of course, is that it's self-reported, but it corroborates to some degree what the MIC evaluation says. In the past, she's had mental illness problems, and less so now. And the number 2 point, Your Honor, is that the complainant in this case, in both cases, misdemeanor, your court, not interested in hurting this woman. She filed on prosecution, but there was a damage made by glass broken up against her eyes, so there was damage. She's remorseful for that. Her plan is to live with a 35-year-old friend of hers that she's known for a couple of years. There's no more contact between the boyfriend and the complainant, who is the boyfriend's grandmother. That's finished, that's over. And she doesn't plan to return to that. I asked the court to consider deferred adjudication with some type of supervision regarding where she's going to live. Nothing further, Your Honor.
Right, so let me understand this. So the facts of this case are that the elderly person was in an argument with her grandson. Is that correct?
No, Your Honor, the other way. The
It says,
grandmother
it said
was,
she had been arguing with her grandson and the suspect got involved.
oh, prior to that, yes, Your Honor, but the real issue was conflict between grandma and her.
All right, you want to raise your right hand? Do you solemnly, right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Vanessa,
All right, I'm having trouble hearing you.
Louder.
Vanessa.
All right, so what is your relationship to the victim in this case?
There's no relationship anymore. But, I was with her grandson.
All right, so you, and how old are you?
24.
24. And how old is the grandson?
He just turned 20 in January.
All right, and you were living with her?
I was living there for about 5 or 6 years
You were living with her?
with her and the grandson.
All right, but that's her house, right?
Yeah.
It's not the grandson's house. So you come in and you live with the grandmother and the grandson.
Yeah.
And then she gets into an argument with her grandson. And what was that argument about?
I don't remember, the exact details due to the fact that
I'm sorry, I can't hear you.
I don't remember the exact details, because I was under the influence.
Under the influence of what?
Xanax.
All right.
Talking to my face.
So she's in an argument with her grandson, and then what do you do?
So I was, I guess, like in the middle, I guess, there was a lot of things going on, due to like a lot of abuse.
You have said some things, but you haven't told me anything. So.
Yeah, Your Honor, how
Yeah.
did she get hurt?
So I got pushed into her.
No, that's not what this says. Because if you were just pushed into her, then maybe you need a jury trial. If you're saying you were just pushed into her. But that's not what it says. In the police report, it says, while on patrol in a marked vehicle, I was dispatched to the listed location for an assault in progress. The caller stated his brother and the girlfriend were arguing, and the girlfriend hit the grandmother. The caller stated the grandmother was bleeding from her head and nose. I arrived to the listed location and saw both victim 1 and O1 sitting outside on the porch. Victim 1 had visible injuries on her face and head. Victim had a small cut on the bridge of her nose, which was still bleeding. Victim had a small cut on the top of her head that was covered in blood. Victim also had a lump on the right side of her head. Victim said she had been arguing with her grandson. Victim said she had been arguing with her grandson, and the suspect got involved and began to argue with her. Victim said she doesn't remember how or what she was hit with, but the suspect walked up to her and hit her. O1 said suspect had threatened to beat up the victim before. So unless you were on Xanax all the time you were at that house?
I was on Xanax for the last 2 years that I was living there.
Mhm. All right, is there anything else?
Moment, please, Your Honor. Nothing further, Your Honor.
So why were you not living with your parents?
So, and,
Sorry, I cannot hear you.
So I'm from Wisconsin and moved at 45.
You're from the what?
From Wisconsin.
Okay.
And so I moved in with him and I was living with him basically for both of them because.
Did you have a job?
No.
How long have you been unemployed?
Since I got with her grandson.
And how long has that been?
About 6 years ago. 5.
So 6 years you have been unemployed. So why did you leave Wisconsin to hook your life to this person?
It's just being young.
Because your parents said they didn't like him or something, and you decided to do it anyway?
No, my parents have approved, but at the time.
And how old were you when you met him?
So I met when I was 16, but I didn't start a relationship until I was 18. Like about a week after I turned 18.
And how far did you go in school?
9th grade.
9th grade? Yeah, so it sounds to me like you were not listening to your parents. Did your parents want you to get your degree or no?
They did, so I was taking care of my mom. My mom is disabled, and so I was taking care of her, working at the time, and I had a part-time job going to school. And I was taking care of my mom, which she's disabled, and my little brother who's also with autism. So I felt like I had a lot on my plate, and so I chose to work instead of go to school.
and then you chose to leave them on their own because you wanted your own life.
Well, my mom had got married and so she met her husband, which he still takes care of.
Mhm. All right, what is her criminal history?
Felonies, Your Honor.
So the only history she has are just the two cases that have been before Your Honor, which is this injured elderly and then the concurrent misdemeanor.
Violation of protective order? And is that with the same person?
Yes, with the same person, yes, Your Honor.
And when did that occur?
That occurred about a month after this took place.
So she had a,
Summary of those facts if you like.
well, what date was the violation of protective order, the offense date?
December 17, 2024. This happened November 27th.
All right. So you want to tell me about this violation of protective order?
So I've never like been in trouble before, so I didn't realize like whenever I didn't know how the law worked basically.
Well, I mean, if somebody tells you, if you receive an order saying that you can't contact somebody, that's how the law works. The order says you can't contact them.
Yeah.
So continue.
So I had went to pack my stuff and so I was getting ready to leave and I guess the grandson had got mad that I was getting ready to leave because I was wanting to leave him too. I was with him for 6 years on and off abusive relationship. So because I didn't really have family here in San Antonio, it was harder for me to like just walk away from the relationship.
All right. And what is this case about? The violation of protective order?
So essentially, the same victim in this injured elderly case had concerns that there were other people in the house that doesn't where. So she calls 911, police respond, she lets some kids in the house and they find this defendant hiding in the closet of her boyfriend's room. And she's removed from the.
All right. So obviously you knew there was a protective order because otherwise you wouldn't be hiding in the closet.
Well, I was forced into the closet. The grandson had threatened me into going into the closet.
Well, the story you're telling me makes absolutely no sense. You have a protective order that you're not supposed to be there. You go there anyway. And now you're saying that you were hiding in the closet because the boyfriend told you to hide in the closet.
Well, he was very abusive. He had weapons and things like that. So I was very afraid of him. My family could testify to the abuse as well. They had called the police on him multiple times before all this occurred.
And when they called the police on him before, what did you do? Did you do an affidavit of non-prosecution or say, my family is not telling the truth?
So they never gave me like the option or like explain that to me how the affidavits work.
No, I mean, it's either you said yes or no, because times have changed. When the police are called out for an abusive situation, your attorney will tell you somebody's getting arrested.
Yeah. So
now, after the
he would
fact,
get arrested and his sister would bail him out within like a few hours. So he would be home immediately after being arrested. So even when he had a protective order, the first time he got arrested, he was still back and he was
because the protective order, the house you were staying in, that's not your house. That's his grandmother's house. You all are adults just decided to impose yourself on his grandmother. You're there, you don't have a job, and you're just living off the grandmother.
No,
and now,
still from my family.
No, you told me that you hadn't worked in 5 years or 6 years.
Yeah, so
due to the relationship, I wasn't able to work and I also didn't have, like, my birth certificate for a long time, so I had to get it sent out.
Here's the thing, I don't even know if you understand what you're saying to me. You keep changing your story. You told me you didn't have employment, that you hadn't worked for 5 to 6 years. And then now you're telling me, no, I wasn't just living off the grandmother. I had my own money. No, you didn't. You hadn't been working. I mean, you're saying, but you're telling me completely different stories. And now you're telling me that you have a 35-year-old that you're gonna live with. Who is this 35-year-old?
It's a friend of mine.
Who?
I don't know how to explain it. It's a friend of mine.
What's the name?
Jennifer
Jennifer what?
Ramos.
And where did you meet her?
So me and her know each other through mutual friends, and then we met, I don't know, I guess like in the neighborhood and stuff.
I'm sorry, met what?
In the neighborhood, I guess, or
So you're just meeting people in the neighborhood and now you're gonna live with them? Does she have any children? What are their ages?
23, she has a 23-year-old, a 15-year-old. And then she has one that I think is like 10 years old.
All right, so if I give you probation, I'm not allowing you to live in homes that have children in them. So, and do you know who all lives in that home other than her and the children?
No, it's just them. It's just them.
Are you sure? Have you been to the house? Do you know she has a boyfriend?
She doesn't have a boyfriend.
All right, so when have you been to the house?
So I was there once. I don't remember exactly when, like I said, I was like.
Was that before or after the violation of protective order?
That was before.
All right, counsel, I don't know if she would be a good candidate for probation. I really don't know.
The remedy of sending to prison is a far worse remedy than trying to find a place for her to live, Your Honor.
Well, I know the state is asking for the minimum. And she applied for deferred adjudication.
He suggests going back to family in Wisconsin.
What I can tell you is you've applied for deferred adjudication. The state, according to the plea bargain agreement, they're asking that if I find you guilty, that your punishment be sentenced to 2 years in the prison. That's the minimum. If I grant your application for deferred adjudication and you're unsuccessful, you're looking at 10 years in the prison, potentially. Do you understand? So I can grant your application for deferred adjudication, or I can sentence you to 2 years in the prison. And the conditions that you receive are the conditions that you receive from me. There's no need to argue about the conditions that I'm gonna set for you if I grant your application. So do you want the minimum 2 years in prison, or do you want to be on deferred adjudication with the court's conditions? Are you sure? Because let me just tell you, you know yourself better than your attorney knows you, better than I know you. I know that you've been dishonest with me today, but your choices are, and you need to think long and hard about it. 2 years is the minimum. The range of punishment for this offense is anywhere from 2 to 10 years in prison. If I grant you deferred adjudication, if for some reason your deferred adjudication is revoked, you're looking at potentially 10 years in the prison and up to a $10,000 fine. So you know whether or not you can complete this successfully or not. Part of being on probation is you are not allowed to use drugs, period. There's no marijuana, there's no Xanax, none of that. And I'm not going to allow you to reside in any home with children. You're an adult, you need to get your own place, you need to stop depending on other people. Do you understand? So, do you want the 2 years in the prison or do you want deferred adjudication? All right. Yes. Yes. All right, this is what the court will do. The court is going to sentence you to 8 years deferred adjudication. There's a $1,500 fine. Time and money will run concurrently. Oh, I'm sorry, state. Oh, you're right. Thank you. State your excuse. I appreciate that. So there's a $1,500 fine probated. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing with minors or anyone over the age of 55. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's an affirmative finding of family violence. There's to be no contact with Carmen Rivas or Hector Rivas. This is to run concurrent with 2025 CC 003873. Can I see the MIC evaluation again, please? Thank you. Thank you. In custody, the following: a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, follow all TAP recommendations. There should be 200 hours of community service restitution. 100 of those hours will be deemed satisfied. You're going to obtain your GED. Do you understand? And the other 100 hours will be deemed satisfied if she obtains some type of trade school certificate or higher level of education. Do you have any children?
No.
All right, and you're saying you're thinking about a transfer to Wisconsin?
Yes.
Which county?
I'm not sure the exact county, but it's in Milwaukee.
All right, let me see what Google tells us. Oh, they're saying it's Milwaukee County. So transfer to Milwaukee County. Field visits 1 time per month until further notice, and 90 sober meetings in 90 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, yes.
Judge, can you repeat the sober support meetings?
90,
Okay, and anger management possibly?
yes. I'll add anger management. All right, we can go off the record. Here's the thing, before you get in another relationship with anyone else, you need to get your life together and decide who you are and what you want to do in this world. You understand? She's in her world. Maybe probation will help her. Good luck.
Thank you, Judge.
You're welcome.
Right over here, man.
So it's not often we get a unanimous poll, but I'm closing it out right now. 100% of you who responded feel that she will not make it through the deferment. And I would tend to agree with you. I don't see how that's going to work out. So I was going to potentially go a little bit east to Jefferson County, but the 2 courtrooms I was monitoring there, Judge Stevens and Judge Holmes, just very suddenly went silent. So they either lost their internet or power or something. So let's just go a little bit further east. We will go to the great state of Louisiana, They are doing revocation and parole hearings. Let's see what's going to happen with this young lady.
Committee on Parole is called to order. It's 9:10 a.m. on Thursday, June the 12th. Our first parole case is at Washita Parish Corrections. My name is Cheryl Renanza, serving as chairman of today's parole panel. Seated with me today is Mr. Danny Barra and Mrs. Carolyn Stapleton. We are at DOC headquarters in Baton Rouge, and I'd like to get the staff here to introduce themselves for the record. Jessica, as I said, our first remote location is at Washita. Would the staff there at Washita please introduce yourself for the record?
Good morning, it's Deputy Marshall.
Thanks, Deputy Marshall, for accommodating us today. We appreciate it. As we proceed through the day today, we will allow public comment before any action item. So our first case is Reagan Bruce. Good morning, Ms. Bruce.
Good morning.
Would you introduce yourself? Tell us your name and your DOC number.
Yes, my name is Reagan Bruce and my DOC number is 764714.
All right, thank you. And we have with us seated in Baton Rouge today, we have in opposition, parents of the victim is Annette Bellinger and Mr. Jeffrey Bellinger. I apologize if I mispronounced your name, but I'll get you to introduce yourself. We'll hear from them in just a moment. First, let me read some identifying information into the record, Ms. Bruce. You're classified as a first felony offender. You're currently serving a 20-year sentence. You were sentenced in Lafourche Parish, June 28, 2021 for vehicular homicide. Your parole eligibility date is June 25th of this year, and your mandatory release date on good time is June 30th, 2026. Is that information correct?
Yes, ma'am.
All right. So, Ms. Bruce, we'd like to hear first your statement before we hear from the staff there and the victim's family. We want to hear your statement. How did you wind up where you're at? And why do you think we ought to vote to release you early?
Okay. I've done a lot of self-reflecting these last 5 years. I've dealt with past trauma that I didn't know how to cope with sober, and I've taken a lot of classes. I've learned how to deal with life stresses sober, and now I know who to stay away from, what to stay away from, and I mean, I'm sorry.
We'll talk a little bit more about that in a minute. Deputy Marchand, is there anything you can tell us about Miss Bruce?
Since she's come to us and been in our work release program with Sergeant Misty May, she has had no incidents, no write-ups, and comes with a recommendation from all women's work release staff.
All right, thank you, sir. Before we get into our interview with you, Ms. Bruce, we'd like to hear from the victim's family, and I believe it's Annette that's going to be speaking. If you step up to the podium, and we'd like to hear what you have to say. Excuse me. Okay.
First, I'd like to thank the forgiveness and opportunity. I only hope what was said is true. I do know that in 2021, there was a legislation enacted and revised the statute 14-405, which is to protect families of people who are incarcerated of being harassed through social media. Am I surprised that nothing's showing up? Yes. We did file a complaint, Kelly from MAD. We filed a complaint with the lieutenant at the facility where she was at. The reason I'm here today probably may not have, because the inevitable is going to happen. She's going to bring Will we ever have our daughter back? No. Will our granddaughter ever vote her mother? No. She will. But our granddaughter cries. The reason why I'm here is because last year, Bruce, who's on social media, she sent friend requests to several of my nieces. The most devastating one was to send our daughter, our only surviving child, a friend request through social media on Facebook. She was doing it through private messaging. Nothing was ever done. We never heard back. There is a law, and that is my concern with this Bruce. And as of 7 weeks ago, she has continued on social media. And she goes by the name of Kim Spice. It's there. Her children are in the background. We come from a very small community. So we all know each other. She lives in the same neighborhood as our granddaughter's father's family, a whole bunch of them. My point is that I've known her since she's little. I was her brother's teacher when her mother was killed not far from where she killed our daughter. This was not an accident. This was a crash. She made that decision to get behind the wheel of the vehicle in the condition she was in after being pleaded not to get on the highway, which has been, maybe it was her past, maybe that's what brought her to where she is today. But why is she still on social media? Why is she still not following the laws like we all have? And I think the most devastating, and you have a copy of it, is her profile picture with the most disgusting thing in the words of a song about someone getting, I'm not even gonna read it because the words are, but it's basically someone getting drunk and having a crash, which is what she did. She took our daughter, who will be forever 28 years old, who left behind a child that was 3 years old, that we now have full custody of. You have in front of you the documents that states that Reagan Bruce, upon release, and I'm here because the inevitable is going to happen. She will get out. And I pray that she learned a very valuable lesson. She took a precious life from us and from the community who is thriving in the school system. Our granddaughters at a function today are the thing that her mother was in charge of. And we're trying to get back to her because we never missed anything. My point is that there's a document there that was issued by Judge Abel. I wanted a protective order for this child until she was of an age that she could fend for herself. Judge Abel not only allowed that to happen, she has a lifetime stay away order from this child. One of my guarantees is she can't follow this law, that she's going to follow that. That is where my concerns are. And I'm hoping that everything she said here today is truthful, because I lived my life in faith. And by God, that's why I'm still here today, because we're still grieving the loss of our beautiful daughter that she killed. This was not an accident. This was a choice she made 7 years ago. She was in a rehab. She walked out 7 days later. She killed our dog. She left on her dog. And 7 days later, she killed our dog. My heart goes out to her two children because they have to be suffering the same consequences that our granddaughter is, which is a beautiful child. This woman convinced her father, who is schizophrenic, to bring her to her. This child has been tormented by what happened to her, kissing, sitting on her and telling her she loved her. I want it clear to her to understand that there will come a time when her children may be in the same facilities of schools together. She stays away from my granddaughter for the rest of her life. She has been through enough. We have all been through enough. Thank you. Yes, ma'am. Thank you for being here.
right, Reagan, your case was assigned to me, so, I do have some questions, for you.
Yes, ma'am.
So you heard all that. I wanted just to ask you a little bit about the social media issue. Tell me about it.
Yes, ma'am. I did not add nobody on that. How's she saying that I added people? I didn't add nobody.
No, I think that the issue was requesting, sending friend requests, but we'll
Yeah,
move on.
I
You know,
didn't-
you're not supposed to be on social media, and you understand there is a protective order that you're not to have any contact with the
Right.
victim's child or her parents.
Yes, ma'am.
Okay, so you're in work release. Where do you work?
At OCM, Wichita Contract Manufacturing.
You do.
Say that again, I'm sorry.
Do there.
Production work.
So tell us about you. You mentioned you've taken programs and what have you, and you know how to deal with your past trauma and stay away from the things you're not supposed to. How are you going to remain? As Ms. Bellinger said, you will be released. You have either a parole date or a good time date. What is your sobriety plan?
To continue AA, possibly do outpatient. I'm really interested in Celebrate Recovery and joining a church. I mean, I plan to stay sober. I mean, I just want to be the best mom for my kids. I'm sober, you know?
So do you do AA where you're at? Do they have that program there?
They don't have it here. I did take it before in my parish.
Okay. Your level of education, you claimed a year of college at intake.
Yes, ma'am.
All right. What are you planning to do to support you and your children whenever you go home?
My grandparents own an insurance company, and I got a job already lined up for me.
Right. I did see that in your plan. You do. I'm just going to sit back and listen to my colleagues to see if they have any questions.
How long have you been incarcerated for?
5 years.
Pretty much to the day?
Yeah. Yes, sir.
That's my only question.
They've been incarcerated for 5 years. How did you get on social media? Whether or not you had a friend request, aren't you not supposed to do that while you're in jail?
No, somebody had access to my profile.
Oh.
It wasn't me. And that's what I'm saying. I don't know if somebody maybe hacked me. I would never send them requests. I know I have a stay away order. I wouldn't contact the family, and my parole date was coming up. Why would I ever do that?
That's what I was wondering about that.
I would never do that. Definitely not. Whatever I gotta say to them, I knew they were gonna be here today. I was gonna say it today.
Just curious, did you write a victim accountability letter for them?
I did I brought it to court. My lawyer got it. I didn't read it in front of them.
No.
But I wrote something to tell the family.
Okay, so if they're ever ready to read it, they'll know that.
Okay, I would be glad to do that. I would really actually like that a lot.
That's something for you to know about and for them to know about it. Okay.
How do I go about that? If they're ready, how do I know that I'm able to send one?
Well, you would do it through DOC. You would speak to the victim advisor there.
Yeah, you would send it to us, and then we'll let them know that it's there, and if they ever want it, we'll provide it to them.
Okay, great.
Okay. Is there anything you want to say to close it out for us?
Yes, I want to let the family know that I'm so sorry. I am really sorry that I took an innocent life that day behind a bad decision I made. And I just really hope one day y'all forgive me. I know it's gonna be hard. I completely understand. And I hope one day the daughter really finds it in her heart to forgive me.
All right. All right. I think we're prepared to vote, and I'll be voting first. This has been tough to listen to on both parts. I was pleased to hear what Deputy Marchand had to say. I was pleased to hear what you said, and really hope, as Ms. Bellinger said, that all of it's true and that you really are on the path to recovery. But my vote today, based on the proximity of your good time day, the fact that you made a plea agreement, the fact that you're doing well in work release now, my vote today is going to be to deny your parole. But I do wish you well when you go home. Mr. Byron?
I'm going to concur with Ms. Renata. You've only served 5 years on a 20-year sentence. And you do have an automatic out date on June 30th of 2026, which is not asking a lot. You can concentrate on getting yourself better and programs in prison, and good luck to you.
Right.
Mrs. Stapleton?
I'm gonna concur with my colleague.
All right, Ms. Bruce, good luck to you.
All right, thank you.
We're going to sign out of
Yes, Michael, you did call it. Kind of as expected. She's, only 5 in on a 20, so not all that surprising. Let's go back to Judge Boyd.
All right, so here's what the court doesn't understand. There's a new number 1 and there are 2 violations of condition number 41. So why are y'all not proceeding on those violations?
Not aware of why that's, Judge. I was just instructed by the attorney assigned to this case that they just wanted to withdraw the MTR and hold off on proceeding before that new number 1 was ready, since that would probably be the strongest basis to argue for revocation.
Well, you all need to confer because he has a violation of conditions number 41. That means that if those are true, that's something that needs to be done, because obviously if that was true, there's something wrong with his UAs, maybe, I don't know. And he's on probation for driving while intoxicated. So do y'all want to talk to probation about that?
We have a little bit, Judge.
Okay.
About potentially altering and amending.
Well, is the defense in agreement to altering and amending?
Judge, we've talked about altering, amending and adding a couple of conditions.
And what would those be?
ISP, sober support meetings, potentially GPS if he is able to bond out. I think the bonds are fairly high on his new cases. But while I think that's unlikely, we put a few conditions in place for that.
Probation? Oh, I'm sorry. So they're saying that they want to withdraw the motion. And they're saying ISP and.
I just don't know that felony drug court will take him back at this point, Judge.
Oh, no, they're not.
Right, so I did recommend GPS, intensive supervision, sober support meetings, and the IVR hotline.
And Judge, he does have the ignition interlock and has had it.
All right.
And the other, I'm just handing that to you, Judge. The other, when he submitted other UAs, Judge, there's other 2. So I believe there are 4 total that he submitted, and 2 of them were negative and 2 of them were diluted. So it was negative, dilute, and then negative.
And I'm not aware of any ignition interlock violation.
I'm not aware of any either, Judge.
All right, so you're asking that the motion to be withdrawn, and of course, the court can't proceed if nobody's presenting any evidence. and the alternate amend, so withdraw motion. Alter and amend to include, sorry, you're all requesting full GPS?
Yes. One of the conditions, should he make bond, is partial, and we would be asking for partial.
For what purpose? Partial for? All right. What I'm going to do is I'm going to do full GPS. Once he provides proof that he's employed, the court will reconsider.
Thank you, Your Honor.
All right, so there'll be full GPS, waive fees, ISP, and how many sober meetings probation? All right, there'll be 90 sober meetings in 90 days. Is there anything else probation? Just continue with the ignition interlock. All right. Is there anything else you need from the court?
No.
Anything else from either side?
Judge, I'll just ask, are the 90 meetings Zoom or is that in person?
He can do that by Zoom. I believe they have Zoom. If they don't, just let probation know and we'll figure something else out. No.
Okay, so
It's gonna have to be when he's, well, I will tell you this, I take that back. I said no too quickly. At the jail, they do have classes that they can take that the court will find acceptable to the 90.
Okay.
Okay. All right, is there anything else?
No, Your Honor.
All right, thank you. Thank you.
Excused?
Yes,
Thanks, Judge.
you're welcome. Thanks for standing in.
All right. Ellie has entered the studio, so hopefully we'll yep, hopping up on the counter now. She'll have some chaos here shortly. Let's go to Judge Simpson.
Court calls case People versus Stephen Campbell or Stephen Campbell.
Jordan Hamden, under the supervision of Assistant Public Defender Jay Ballinger, requesting permission to practice pursuant MCR 8.120 without our client.
So hold it. Do me a favor.
Yeah.
All right. You've not appeared before me, right?
No.
I didn't think.
This is my first time.
All right. I know. So do me a favor. First thing is just take a deep breath.
Okay.
Okay. Slow down. Do you have that all written down?
Yes.
You do? So you didn't practice it?
No, I did.
You did?
Yes.
So why do you need the paper?
Just my notes, Your Honor.
So you don't have what you're trying to say to me written down?
No.
Oh. Did Jay Ballinger tell you what to say?
No.
He didn't tell you what to say? Has
Did
he
not.
helped you at all?
Somewhat.
Wow. Here comes the bus. No, it's okay.
No,
It's okay. No, I
joking.
appreciate your honesty.
I'm joking. Jay has been.
No, you're not. Jay has done nothing. We get it.
Chop levers for dinner now.
Did you get her name already?
Yeah.
Okay. All right. All right. So go ahead.
We were not able to get a hold of our client. We
Hold
made.
it. Did she finish the other part? Well, yeah, I interrupted.
I didn't.
Go sit down.
I didn't want to say that, but yeah, I tried to.
Okay.
I tried to.
Whoa, slow down. You're confusing me.
Okay.
Start over again.
Okay. Good morning, Your Honor. Rova Hamden, under the supervision of Assistant Public Defender Jay Ballinger, requesting permission to practice pursuant MCR 8.102 without, 120, sorry. We are not, our client is not present today.
Stop just for a second. You're requesting permission to practice
Yes.
under pursuant to Michigan Court Rule 8.120 under the supervision of Jay Bellinger. Is that correct?
Correct.
Where are you from?
Ann Arbor.
Ann Arbor?
Yes.
You go to high school in Ann Arbor?
Yes.
Where?
WTMC.
Okay, very good. All right, so you grew up in Ann Arbor.
I did.
Okay, then see, that brings you some benefit with me.
Yeah.
All right, so you'll do okay. Where'd you go to undergrad?
Wayne State University.
You're good. Where are you in law school?
Toledo Law. No.
So you were doing well. You were in Ann Arbor, you stayed in Michigan, and then you took off to the disputed territories.
I'm sorry, Your Honor.
All right, permission to practice is granted. Go ahead.
Thank you. Our client is not present today.
Really?
What am I?
We went through all that and you don't have a client.
We do not have a client. I'm sorry.
Does Bellinger know where it is?
He does not.
That's what he told you.
We made every effort to contact our client. We could not get a hold of him. We do understand that there's a bench warrant that was issued June 9th, but we would like to request an adjournment on this matter.
We'll just leave the community corrections bench warrant out. That community corrections bench warrant is a no bond bench warrant.
Oh.
The defendant having failed to appear.
All right.
Thank you, Your Honor.
You know what? I feel so bad for you
Why?
because Bellinger knew that you didn't have a client and he sent you up there to get a bench warrant.
No comment, Your Honor.
All right. Wow.
Wow, Sheriff.
Wow. Did that on purpose to her. Court calls the case, People versus Douglas Hill.
Hey, Richard McDuffie for the people.
Stephanie Cannon with the Public Defender's Office.
Almost. Your name, sir?
Douglas Hill.
Thank you.
And Your Honor, for Mr. Hill, we are asking for an adjournment. We also have an order for inpatient treatment that we're asking the court to sign. All of this has been presented to the APA in this case.
So this is
Mr. Hill.
what I'm calling the Yagi order.
Is that right? Is that right?
Right?
Is that a good thing, Your Honor, or?
No, it's a wonderful thing.
Oh, okay.
That Ms. Yagi has taught the rest of you how to do that. I don't know how many times I had to say, I will grant inpatient treatment. And it wasn't until Ms. Yagi said, oh, well, I'll just prepare an order and have an order ready to go.
And she is I think she's my mentor, actually. I think
She should be your idol.
so there we go.
I will sign that order. I will also grant the adjournment in this case. And I'll set the probable cause for June 26, 2025, 9 a.m. Bond continued. All right.
Okay, we'll talk about it. Thank you.
All right.
Thank you, Your Honor.
Court calls the case of the People versus Frank Clark.
Kerma Dadush on behalf of Mr. Clark, who's appearing on Zoom. Nope. Your Honor, Mr. Clark has not been able to be reached by our office. His phone number is disconnected. He lives in Ohio. The last time he appeared by Zoom, I was hoping he would appear by Zoom today as well.
That's what happened.
I hope he's okay.
People go to the disputed territory. Bench warrant will issue for defendant's failure to appear. Bond 10,000 cash surety.
Okay.
Warrant will issue immediately.
Thank you, Your Honor.
Court calls the case of the People versus Stephen Johnston.
Yagi, Assistant Public Defender with and on behalf of Mr. Johnston. Mr. Johnston, can you state your name for the court, please?
Stephen Michael Johnston.
Your Honor, I am asking for an adjournment. I do have a green sheet. I'd like to continue discussions, thank you, with Mr. Johnston as well as the APA. He does have multiple cases pending, so I think we just need more time to continue discussions.
Probable cause conference will be adjourned June 26, 2025.
Thank you, Your Honor.
9 a.m. Bond continued. All right.
Good luck.
Court calls case People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Clifton. Mr. Clifton, when you are at the lectern, please state your name.
Deshaun Clifton. Thank you.
And Your Honor, we're asking for a 2-week adjournment in this matter. My client has met with our AIM division. They are preparing mitigation information to provide to the prosecutor.
Probable cause June 26, 2025, 9 a.m. Bond continued. Thank you, sir. The court does call the case People versus Christopher Neither.
And on behalf of the people, Your Honor, Roba Hamden on behalf of Christopher Niper, please state your name to the record.
Christopher Niper, Your Honor.
Your Honor, we are requesting an adjournment on this matter, pending media discovery. We are requesting 2 weeks.
You have a green sheet?
I do.
And Your Honor, I believe it's, the media has been released by our office, so it's in the process.
Got it. Probable cause conference will be adjourned June 26, 2025, 9 a.m. Bond continued. Thank you.
Sorry,
want
Your
to address
Honor.
bond?
We would like it to address bond, yes.
Go ahead.
We would like to ask for a PR bond. Our client has a minimal criminal history. He works for Instacart. He is not a flight risk. His father is in law enforcement and has the support of his family. He is able to stay at a friend's house in either Pinckney, Michigan or Ypsilanti, Michigan. Or in the alternative, we would like to ask for a 10% provision on the $5,000 bond.
Your Honor, I would object to any modification of bond. In this case, we requested 10,000. I believe the 5,000 at this time is appropriate. In this case, the defendant assaulted the victim at a gas station, which was witnessed by several people. He then forced her into his vehicle and took her back to the residence, also witnessed by several people in the area. When law enforcement arrived to check on the victim, they were not allowed entry. Eventually, they were able to get her by a window and grab her out of the house. At that point, they took her to safety. The defendant then refused to come out for hours. Eventually, law enforcement had to get a search warrant to get in the house and found the defendant hiding in the house. He has a previous dismissed case with the same victim for a GBH and MDO for the DB, and at the time, I believe bond is set as appropriate to be effective in any modification.
Any additional response?
No, Your Honor.
Motion for bond reduction denied. Bond will continue. Thank you.
Thank you, Your Honor.
All right, our friends in Jefferson County appear to have their power back. Let's go to Judge Holmes, aka Judge Rubber Gloves, and see what's going on.
Okay, Jefferson County Court at number 2 is back in session. Court is in session and calls number 25 CCCR 1154. Case is styled the state of Texas versus Michael Brandon Horn. Mr. Horn, is that your full name?
Yes, sir.
How are you doing, Mr. Horn?
I've been better, but I'm doing okay.
I'm sure you've been worse too.
Yes, sir.
Okay, so now, Mr. Horn, you're representing your case by your attorney, Attorney Robo. Ms. Robo, how are you doing?
I'm doing fine, you.
That's good. State is represented in this case by Attorney Haley Simmons. Simmons, how are you doing?
I'm great, Judge. How are you?
Okay, now, Ms. Provo, what is your announcement in Mr. Horn's case?
At this time, Your Honor, the state has offered him a offer.
Okay.
But he has refused that offer.
Okay,
at
that's
this
fine.
time, based on several reasons why he.
Well, I don't need to know the reasons why he's not accepting.
No,
I just
understand.
need to know at this time. So at this time, we're gonna set this case for an announcement. to give you an opportunity to,
I think that would be fine, Judge. Really, I need to get a hold and speak in person with the complaining witness in this case. I did attempt to this morning. However, the voicemail box was full, so I had no success.
okay. So when do you want me to reset it?
You want to do a short reset?
Sure, 2 weeks.
2 weeks would be fine. I'm sure I can get a hold of him sooner than that.
Okay. But he's on a jail run. I mean, we can just put him on we can put him on the next jail run. Or
Well, we can do.
You want to go ahead and put him on the jail run for next week then,
yeah, we'll
Judge?
do that.
No.
Okay, and give you an opportunity to talk to
The complaining
whoever you
witness.
need to talk
Yes,
to. Okay, so this case will be reset 1 week. All right, Mr. Horn, you can follow the bailiff. You have a blessed day.
Right now.
So this case will be reset June. Yeah, we'll be here June 19th.
Yeah, next Friday, the court.
Yeah, we'll close on that. They took it was June 20th that the court is closed, not the 19th. Okay. The case will be reset Horn for 1 week, June 19th.
All right, not super exciting, but sometimes that's how it rolls. Let's go back to Judge Boyd.
It's always nice to see classmates, because in your mind, you're thinking about law school and other things.
Absolutely. Those images also flash through my mind.
All right, the court is calling 2025 CR 0018028 and 2025 CR 0018001B, State versus Early Ramirez Hernandez. Can I have parties announce?
Rafael Leal for Mr. Ramirez Hernandez.
All right, and we have an interpreter here. If you could raise your right hand, please.
Yes, sir.
Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Bean Abrams, license number 2081.
And I previously asked this before, and I know the answer, but Mr. Leal, do you speak Spanish fluently?
Yes, Your Honor.
And have you been able to communicate with your client about this hearing?
Yes, Your Honor.
All right. Mr. Hernandez, you entered a plea of no contest in each of these cause numbers. In each of the cause numbers, you submitted an application for deferred adjudication. And each of the cause numbers, the state is silent on your application. They're asking that your punishment be assessed at a cap of 12 years. The cases are to run concurrently, and they're taking in consideration 2024 CR 00180, 2025 CR 00180B, 2024 CC 742954. And at your entering of the plea, the court informed you that if the court were to find that there was sufficient evidence to find that a weapon were used, the court would enter an affirmative finding of deadly weapon. Counsel, do you have any witnesses?
Your Honor, before we proceed, I have a mitigation expert
Yes.
that has interviewed Mr. Ramirez Hernandez, and he's asking me, this is a mitigation expert from MAC, the Management Assigned Counsel, and he asked me to request that he will need additional time to give me a report and provide more information concerning Mr. Ramirez Hernandez social history and mitigation evidence.
And how much time is he requesting?
He asking me for 30 days.
I understand you. So you want to call him and let him know, tell him that if he has already interviewed him, and this case has been, since May 30th is when the plea was entered. So if you want to call him and see if.
He says that, Judge, that he was planning on meeting with him 2 or 3 more times to properly develop that.
I can, I'll give you to the week of July 14th? And he needs to have it done by then.
Oh, yes, absolutely.
So will he have it done by then?
I'm sure.
All right, Ms. Ferguson, recall this for July 14th. All right, thank you.
Thank you.
You're welcome.
Center.
Let's hit a different part of the country. We'll head to the Northwest Battleground, Washington. This is Judge Andrew Wheeler.
I'm going to talk to you about your options. One of the things I cannot do today is provide you legal advice. So if you're unsure how you would like to proceed, I am more than fine with having folks have a seat and take some additional time to consider their options. As you see, from the television above you over to my right, we do have folks joining us also from the Clark County Jail. I have a more limited time with the folks in custody. So as a result of that, those matters oftentimes have to be taken out of order. It is not my intention to keep anyone here any longer than they have to be. Just simply, I have less time with the folks that are in custody. Mr. Wallace, did you have a matter ready?
I do not.
Okay, sounds good. Jeffrey Trotter. Sir, if I could have you state your name and date of birth, please, for the record.
Jeffrey Trotter, 07-2277.
Mr. Trotter, you're making a first appearance arraignment on a charge of driving while suspended in the 3rd degree. That's a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with the case, and I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney?
Yes.
Okay, I'm gonna ask you just a couple questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
No.
Are you employed right now?
No.
Any source of income?
No.
I'm gonna find you do qualify for a court-appointed attorney. Court will assign Kenneth Wallace. Mr. Wallace, if you do not mind, I am going to have you speak to Mr. Trotter. I am showing he has warrants from 2018 in the city of Vancouver still pending. Perhaps you could at least bring the court up to speed on what his plan is to get those warrants canceled before he comes back here next time in front of me.
Sure, Your Honor.
All right.
Thank you.
So Mr. Trotter, this is Mr. Wallace. He's going to speak to you briefly this morning, talk to you about those warrants, and hopefully we're going to get those matters attended to. They are 7 years old right now, it looks like. So Mr. Wallace, here's the court file.
Yeah.
Nicole Cranner. Oh, I was hoping he was going to take that. There we go. Thank you. Hello, ma'am. Can I have you state your name and date of birth, please, for the record?
Nicole Craner, 1979.
Ms. Craner, making a first appearance arraignment on a charge of driving while suspended in the 3rd degree. It's a simple misdemeanor subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney?
Sure.
Okay, I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
Yes, in Oregon.
Okay.
Yeah.
I'm going to find you to qualify for a court-appointed attorney. Court will assign. Court will assign Brandon Campbell. Ms. Craner, we're going to enter a not guilty plea at this time. That's going to preserve all of your rights and keep all of your options open. I'm going to assign 2 future court dates. The first is going to be for your attorney only. That's going to be on the 25th of June, 2025. It's not a court date for you. Your next mandatory court date, ma'am, is going to be on the 24th of July,
Okay.
2025. That's going to be at 10 a.m. You can be in person that day or on Zoom. All your paperwork's going to have it. I'm writing all those dates down for you. You can be in person or on Zoom, but we do need to have you here present. Your release conditions, ma'am, are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. So Mr. Campbell can be in touch with you. Is there a phone number I can write on the form here?
Yes, 971-323.
Okay, so at that very far desk over there by the door, we're going to get you some paperwork that has your court dates.
Okay.
I then want you to go to the same place you checked in for court where that glass partition is. There's a table on the left-hand side. It has business cards.
Okay.
Get a business card for Brandon Campbell. Call his office tomorrow. Let him know you've been assigned as his client, okay? Thank you, ma'am.
Thank you very much.
Yep. Pamela Schoonover. Hello, ma'am. Can you state your name and date of birth, please, for the record?
Pamela Schoonover, 52085.
Ms. Schoonover, you're making you're making arraignments, it looks like today, on 2/2021 driving while suspended third-degree charges. The first is a City of Richfield case from February 5th, 2021. The second is a City of Richfield case from March 3rd, 2021. In 2021, I did review the associated police reports with the case. I did find probable cause. You'd previously been assigned a court-appointed attorney, looks like on both cases. Are you asking the court to reassign you an attorney?
Yes, please.
Okay. Has any of your financial circumstances improved at all since you were last screened?
Unfortunately not.
Okay.
Mhm.
Previous attorney, Ms. Landwehr, was Ms. Ward. When we assigned to Mr. Cheney then, or Mr. Wallace? Okay, I'm gonna assign to Kenneth Wallace. So Ms. Schoonover, we're entering not guilty pleas on both of the charges. That preserves all of your rights and keeps all of your options open. I'm going to assign 2 future court dates. The first is what's called an attorney pretrial date. That's going to be on the 25th of June, 2025. It's only a date for your attorney, not a required court date for you. Your next mandatory court date, ma'am, is going to be on the 24th of July, 2025 at 10 a.m. You can be in person that day or on Zoom, but you do need to be present. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number, not to drive without a valid license and insurance. This will be the last time that I don't impose bail on your case. These are 4-year-old cases, and the only way it looks like you came back on this time was you got arrested on the warrants. So you need to come under your own power next time, or you're going to be on the jail camera. And that's not me being angry with you in any way, shape, or form. It's just a 4-year-old case that's not resolved. Do you understand?
I do.
Okay. So Mr. Wallace can be in touch with you. Is there a phone number I can write on the form here, ma'am?
Unfortunately, I don't have a phone right now.
Okay, that's fine. We're going to do a couple of things. I'm going to get you some paperwork at the very far desk over there by the door. I then want you to go to the same location you checked in for court. There's a table on the left-hand side. Get business cards for Kenneth Wallace. Call his office tomorrow. Let him know he's been assigned as your attorney, okay?
Okay.
All right. Thank you, ma'am.
Okay, let me take a moment for a shameless plug and promotion, because some of you out there may not be aware that we don't just do the live show, we don't just do regular videos, we don't just do shorts, we also have archives. And currently we have streaming 24/7 a Judge Fleischer archive. We're sitting on a whole ton of footage from the judge. We've got about 45 or so hours that loops on a 24/7 basis from his dockets, and we've got about another 120 or more that we're processing that'll be added to it. So if you're interested in such things, we encourage you to go check it out. I'm going to drop a link right now in the chat as well. If you stick around to the end of this live show here, YouTube will take you right over to that program as well. So if you like you some Judge Fleischer, we can't get him live anymore because he stopped streaming, but we've got all sorts of footage, and to be honest with you, every time I watch the stream, I find something that I hadn't seen before. So be sure to check that out. Let's go to back to Jefferson County, and we'll go back to Judge Holmes.
Fed Law number 2 is in session in 2 cases, cause numbers M333254 and cause number 23CCCR 0195. Case is styled the state of Texas versus, is that Cashman Roberts?
Yes, sir. Cashman Roberts.
How you pronounce it?
Cashman.
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 Cashman, okay.
Told you,
How you
Jay.
doing?
I'm doing all right.
All right, that's good. Now, Mr. Roberts, you're represented in your case by your attorney Jennifer DeLodge. And Ms. DeLodge, how are you doing?
I'm doing great, Judge.
Okay. And the state is represented in this case by Attorney Haley Simmons. Now, Mr. Roberts, the reason why we brought you in, before we do anything on your case is because, there was, something that had occurred, a few weeks ago. Did, you call, our office?
Yes, sir.
Okay, in reference to these cases?
Yes, sir.
Okay,
1,000 times.
and you said 1,000 times?
Yes, sir.
Okay, all right. And you left a message,
Yes, sir.
right, pertaining to this case. Is that correct? And I don't know if anybody, did you talk to anybody?
No, sir. They didn't know if I answered the phone.
Okay, okay. And one reason why I think you left messages, but you didn't leave your phone number, a callback number.
And I sent my grandfather up here too, JD Roberts.
Okay,
Yeah, he came up here too to talk to you.
okay. So you say you sent your grandfather up here to talk to me about the case.
Yes, sir.
And just for the record, Mr. Roberts did come up here.
Yes, sir.
He appeared at the front, but I did not talk to him about the case because we kind of put two and two together that you called. You had the same name of the other gentleman that came a couple of minutes later regarding your case. And so, there was a conflict. And so I did not talk to you. Is that correct?
Yes, sir. You
And just for the record, I did not talk to your grandfather on that day about your case. Now, I did see your grandfather at a graduation party. I'm thinking of gentleman, my daughter and I gave a scholarship to a gentleman. His last name happened to be Roberts.
Yes, sir.
And they invited us to the party. Your grandfather was there. Your grandfather approached me about not returning calls or whatever. I told him what I've just told
Yes,
you
sir.
today, that you called. He came by, we put two and two together that he was probably coming on your behalf, and I could not talk to him. And I did not talk to him.
Yes, sir.
And so, now I do know your father. Your father is a friend of mine. However, I did not, well, first of all, did I promise you anything regarding this case?
No, sir.
Okay, and I did not talk to your grandfather
Yes, sir.
about the case anyway. And just for the record state, have I been involved in the giving any offers or participation of any offers in this case?
No, Your Honor, state sees no concerns and we waive any form of conflict.
Okay, so the court is willing to, recuse itself, but the state, you're waiving any possible conflict of interest or any appearance of impropriety.
Yes, Your Honor.
And Mr. Lodge.
Same, Your Honor.
Okay. So at this time, I'll stay on the case. We'll be calling you out in a few minutes. You have the paperwork ready? Okay. Okay,
We're
well,
ready on him?
yeah, we can do it right now. No, we was ready.
Works for
And
me,
it's
judges.
Hush.
Hash, man. Yes, sir.
Okay.
Are we gonna keep this plea on the record as well, Your Honor?
Yeah, we can keep it on the record.
It's already on.
Sorry.
Yeah.
Man. I was ready to get this behind me.
No, that.
Here we go. Which one you playing on?
He's playing on 23 CCCR 0195.
95, okay.
The dismissal is on the M charge.
That's correct, Your Honor.
Okay. Now, Mr. Roberts, I have before me two cases, cause numbers M333254 and cause number 23 CCCR 0195. And Mr. Roberts, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Roberts, you may put your hand down. Mr. Roberts. I have before me in clause number 23 CCCR 0195, a document that is titled Information. This information is on my computer. It was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Koshman Roberts, on or about, is that June 12th?
Yes, sir.
Okay, today's date, okay. On or about June 12th of 2022.
Not notice that.
I noticed it last night.
That is random.
Yeah, on about June 12th, 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with alcohol concentration level of 0.15 or more. Mr. Roberts, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Roberts, how do you plead guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir, I know.
And are you pleading no contest because you do not wish to fight all contested charges?
Yes, sir.
Ms. DeLodge?
Yes, Your Honor. Oh, sorry.
It's supposed to be, I think, it's a Class A misdemeanor.
Did I
Just
get
check,
the,
just check the box, Class A.
sorry about that. Oh, I did the
DWI, I know.
I got you. Okay.
I don't think they've changed the statute yet.
You're correct. I know what you mean
Yeah.
now. Sorry about that.
Okay.
So all we did here was change the checkbox from DWI first to a Class A misdemeanor.
And
it just changed the punishment range just a little bit, what it would have been. But
so,
yes.
so now, Mr. Roberts, I have before me a document that's titled misdemeanor plea admonishment, also labeled as State's Exhibit 1. Do you recognize this document?
Yes, sir.
Now, there's one box that's checked on the first page. The box that's checked states that this is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum 0 days to maximum 365 days in the county jail, which is 1 year, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Do you understand the range of punishment for DWI first? I mean, DWI with a Class A DWI with a 0.15 or more. Now, I also have a document, also the same document on page 2, there's a set of initials on the line that's checked with a box that is titled Nola Contendere, which means no contest. Did you place your initials on this
Yes, sir, I
document?
did.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir, it is.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? And at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that
Yes,
statement?
sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the
Yes, sir.
line that's titled Defendant? Now, Mr. Roberts, before you sign and initial all of these documents, did your attorney, Mr. Lodge, go over these documents with you?
Yes, sir, she did.
And did you read and understand everything in these documents?
Yes, sir, I did.
And is everything in these documents true and correct
Yes, sir, it is.
to the best of your knowledge?
Yes, sir.
And Mr. Roberts, are you a citizen of the United States?
Yes, sir.
State up for state one.
No objection.
No objection. State's Exhibit number 1 will be admitted. And Mr. Lodge, you have advised and counseled Mr. Roberts. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Roberts, your attorney, Mr. Lodge, has advised and counseled you. Are you satisfied with with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir, she has.
Mr. Roberts, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 114 days credit for time served, tax and retired court costs, and we're dismissing the companion case calls M333254.
Okay, Mr. Roberts, the state is offering that you serve 114 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already served 114 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. The state will also be dismissing clause number M333254 in relations to this plea bargain agreement that you have made.
Yes, sir.
Now, Mr. Roberts, do you understand the state's offer?
Yes, sir, I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir, it is.
And do you accept the state's
Yes,
offer?
I do.
Okay, Mr. Roberts, I'll follow the plea bargain agreement that you have entered into with the state, Mr. Roberts. If you do not have anything else holding you in jail, you should be getting out of jail today. Okay, so Mr. Roberts, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go. And it's Koshman. Is there a Koshman Jr.? Okay, you got a unique name.
I know, and it's spelled like Kajong.
Uh-huh,
That's how I want to say it.
yeah.
All right, let's change it up a little bit to end the day here. We're going to go to Detroit. This is Magistrate William Burton, and he is doing appearances from the Detroit Detention Center.
Pre-trial for this matter will be June 26th for Judge Michael Wagner. Is that clear, sir?
Yes, sir.
Is that clear? All right, now to your main matter. Case number 230-572-6301. Peter said Michigan versus Shantez Milligan. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Are you gonna be here?
Shad, Mr. Reagan.
Yes, it's me.
This is Mr. Milligan.
Jessica Shab on behalf of Mr. Middleton, who is for more reading understands his constitutional rights and stands here.
Court will deny guilty plea on behalf of Mr. Milligan. Bond recommendation from the people.
Recommending a 10,000 personal. This is non-assaultive. It's back from June of 23 and no contact with complainant Ms. Parnell.
No objections.
$10,000 personal bond, Mr. Milligan. They don't know each other, do they?
It's
Kinda.
yeah, they do know each other.
Daughter's boyfriend. The defendant is her daughter's boyfriend.
Okay.
So,
All right, no contact. I'm sorry, go ahead.
I apologize. We're talking over each other. I'm sorry. I just said he's the daughter's boyfriend, so they were associated at some point.
So, and Your Honor, we were gonna ask for no assaultive contact because the complaining witness keeps my child's baby and this is a non-assaultive case from 2 years ago.
All right, given the age of the case, no assaultive contact. $10,000 personal bond, probable cause June 20th, preliminary examination June 25th, both in front of Judge Patricia Jefferson. Any questions, Mr. Milligan, regarding your bond and or court dates?
No, sir.
All right, step aside, please.
I know you can. You and them, I think it's 4. Come on. You got a personal bond. You going upstairs, right? Takes a minute.
What's your name?
Burke, a second.
Eric Burke? Is that your name, sir? I see lips moving, but I don't hear any sound.
Eric Burke, a second.
All right. This is case number 25044470001. Precinct Michigan versus Eric Burke. Appearances, please.
Thank you, Steve Benson for the people.
Justice Schreiber, on behalf of Mr. Burke, who has formal reading, understands his constitutional rights and stands mute.
All right, the court will enter a not guilty plea on behalf of Mr. Burke. Bond recommendation, Mr. Vincent.
Magistrate, at this time, we're comfortable with a personal bond. We would be asking for a condition, no alcohol. And just so you know, I know you go over the investigator's reports. He was on probation at the time. I think he was candid with the police about that, but he's successfully completed that probation. It was a CCW that was reduced down to a gun charge misdemeanor, but he completed all of that. No other alcohol-related convictions.
Okay.
No objections.
$10,000 personal bond, Mr. Burke. No drinking, no driving without a valid license. Pretrial, June 25th, and both in front of Judge Bryant. Step aside, sir.
And those court dates again, Your Honor.
June 25th, in front of Judge Bryant.
He's Michael Fry.
What's your name again?
He's Michael Fry.
All right, this is case number 240-456-7201. Precinct Michigan versus Keith Fly. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Judge, may it please the court, Philip Reagan on behalf of Mr. Keith Fly, Judge. I don't know if we have the right gentleman, Judge. I don't think this is the right person.
Nah, sir.
Why do you say that, Mr. Reagan?
They have my client is well, this gentleman right here is a 50-year-old white male, date of birth. I don't want to give his date of birth, but the Keith Fry that we have says 45-year-old black male, 11/24/78. It's a whole different description, Judge.
Agreed.
Recommendation from the people?
Well, Your Honor, based on the investigator's report, he does not match the physical description, so he would need to be printed.
He said he took the fingerprints yesterday just to prove that it's not him. I think at this point, the Detroit Police Department needs to let him go, Judge, or figure out who the right person is.
DDC?
Yes, Your Honor.
How do we know, if we do know, that this is the right person for this case?
And the guy.
Well, DPD took the photograph, so I wouldn't know. I know he was printed, but I don't know anything else. Don't have the results. And I think I heard, I don't think they have the results back, Judge. So can we maybe recall this and we can have DPD, because I know that Detroit Police, that this is something they would need to do. It's just, it's not a DDC issue, but it's a.
Okay, we're gonna put this over to this afternoon.
Okay.
Okay.
So Judge, but I understand the court's position. I don't want them to have to hold this gentleman any longer in custody than maybe let me try to see if I can find somebody. I mean, because DPD printed them, so they should be able to.
Okay, Mr. Reagan, over the lunch hour, I can check on my end what I need to do. I just want to put it over to 2:30.
Thank
All
you.
right, step aside, sir.
Thank you, Judge.
So I watch way too much court to remember for sure, but somewhere along the lines, I've seen this 2 other times this week where they've had somebody, not Detroit specifically, but in other courts, where they've had somebody in custody and they're unsure that they've had the right person. So I don't know what we do about that other than it's got to totally just suck for the person who is potentially being held in a case of mistaken identity, because their life is just upended. Well, the slow-moving wheels of justice try to figure out exactly what's going on. So hopefully they get it figured out soon and get this guy out. So we're going to go ahead and call it for today. I hope you all had fun. A little lighter day than what we've had so often, you know, not super heavy cases and whatnot, because we've had a lot of that lately. So a little change of pace today. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Half an hour earlier for channel members. If you're not a channel member, go to that pinned chat, and you can find the link there to join us. It's $2.99 a month, real cheap, but it gets you access to the pre-show amongst other things, so it's worthwhile. Go have yourselves a great Thursday. We will see you again tomorrow. Ashley says, thank you, Dan. No, Ashley, thank you, and thank all of you. You're the reason why I get up at dark 30 every day, because I just love interacting with all of you. It's a great time, and I appreciate it. So take care. God bless. We'll see you tomorrow.